Hello guys, welcome to Legal Brilliance. Today we are going to discuss about one of an important topic of evidence law, privileged communication. Introduction. Privilege means a right or duty to refuse to disclose a fact. This right is based on convenience and public policy. Section 121 to 132 of Chapter 9 of Indian Evidence Act deals with provisions relating to privileged communication. Meaning. Privileged communication means a protected communication between two or more individuals. By this protected legal relation, they are not bound to disclose any detail of such communication to a third person, either can be compelled to disclose information of such communication. Essentials. First, communication should take place between two or more individuals who are in protected legal relationship. Communication must take place in private. Information cannot be disclosed to a third party or a third person. Now we'll discuss about kinds of privileged communication. First kind is judges and magistrates, section 121. Communication during marriage, section 122. State privileges, section 123. And professional communication, section 126. Now we shall move into a detailed discussion about each of the following communications. Judges and magistrate, section 121. As per section 121, no judge or magistrate can be compelled to disclose anything that came to his knowledge in the court as judge or magistrate. In the court, working as judge or magistrate, or anything that came to his knowledge in the course of his employment as judge or magistrate, except upon a special order of some court or some superior court to which he is the subordinate. Example, A on his trial before Court of Session says that disposition was improperly taken by B. Here B is the magistrate. Thus, B cannot be compelled to answer to this question as to whether the disposition was improperly taken or not. Here, the judge can be compelled to disclose or compelled to answer to this question only by the special order of some superior court to which he is subordinate. Communication during marriage, section 122. As per section 122, a married person shall not be compelled to disclose any communication made to them during the marriage by their spouses or ex-spouses. They are also not permitted to disclose anything without their spouses or ex-spouses' consent, even if they are willing to. Conditions are: the communication must be made during the continuance or subsistence of the marriage. Only communications are protected, not the acts or conduct of the individuals. The privilege operates on husband and wife, not on third person or a third party. The privilege does not end after the termination of marriage. It extends even after the termination of marriage, and they are bound by their obligation to non-disclosure of any information related to any communication that happened during the subsistence or continuance of marriage. Now we will deal with few important cases of section 122. First, S.J. Chaudhary versus the state. It is one of the very important case. In this case, the court held that the communication between husband and wife or the spouses are privileged, and compelling them to disclose any such information is far worse than getting any information at all. And hence, these communications were held as inadmissible in the court as evidence. In Emperor versus Ramachandra case, the court held that any communication between husband and wife is privileged, no matter what the means of communicating was. Here, the means of communication is not important. Any communication that takes place during the continuance of marriage, it is privileged communication under section 122. There are few exceptions for this. The privilege given under section 122 is not absolute, and it has certain exceptions. The first one is crime committed against another. So, in case of a civil suit or a proceedings against each other, any communication, any communication happened during the continuance of marriage can be used as a evidence to defend themselves in the court of law. Second is consent, and the consent must be express, not implied. So, for the purpose of section 122, either of the spouse has to expressly consent the other spouse to disclose such information from their communication. Unless and until such express consent has been given by either of the spouse or ex-spouses, the other party or the other person cannot disclose it to a third person. State privileges, Section 123. As per Section 123, no individual is permitted to give any evidence that might be gotten from any unpublished record of any state affairs. Here, unpublished record means any records of state affairs which is yet to be published or which is not yet published. However, such evidences, such unpublished record can be admitted in the court as evidence, but with the permission of the head of the department concerned. Now, giving such permission by the head of the department is his sole discretion. He can either give or withhold such permission. So it is his sole discretion, and it is up to him whether to give permission or to withhold such permission to use such unpublished record as a evidence in the court of law. One of the very important case for this point is State of UP versus Raj Narayan. In this case, the court held that when public interest it outweighs the administration of justice, evidence cannot be admitted. So here what it means that when the evidence procured itself is detrimental to the public interest, such evidences are not admissible. Section 124, Official Communication. The communication made to a public officer may be held in official confidence because such communication could hurt the public interest if exposed. If any such communication made to a public officer, if it does not include any issues of state or hurt the public interest, it might be taken as evidence. The same was held in Ray Mantubai Mehta case. wherein the court has clearly mentioned that if any information given, if it does not affect the state or if it does not hurt the public interest, it can be accepted as a evidence in the court of law. Section 125, Secret Informant. Magistrate or a police officer cannot be compelled to reveal as to how they got information regarding the commission of the crime. The same principle holds good in case of revenue officer. Example, A is a revenue officer. Someone told him that B was hiding millions of rupees in black money in his basement. Here, A cannot be compelled. A is revenue officer. Here, the revenue officer cannot be compelled to tell as to how or where did he receive such information. In another example of a journalist, a similar privilege is given to journalist as well, wherein the journalist also have a press source privilege. This secures the journalist from uncovering their sources. Professional communication, section 126. This is one of the important section of privileged communication and also important section of evidence law. As per section 126, any communication between an attorney and his client is protected and it remains confidential. This is why it is commonly called as professional communication. In India, a legal practitioner is not allowed to reveal such information that client had disclosed to him or any advice that the lawyer had given to his client. Example, A is a client and he says to B, an attorney, that I have committed forgery and I wish you to defend me. Here, this communication between attorney and his client is not in the furtherance of criminal purpose, rather it is a communication made with an attempt to seek attorney to defend client in his court proceedings. So this communication is protected from the disclosure. And it is very much important to know that the obligation stated in section 126, it continues after the employment has ceased. On termination of employment also, this obligation will extend. As per section 126, following communications are not protected or permitted. First, communication made for unlawful purpose whose object of such communication is commission of crime. Example, A is a client says to B, an attorney, that I wish to obtain possession of the property by the use of forged deed on which I request you to sue. This communication, since it is being made in furtherance of criminal purpose or illegal purpose, it is not protected from disclosure. Second, when after employment of the lawyer he observes that some additional crime has been committed. Example, A is charged with embezzlement. Now he approaches attorney to defend him in the court. In his course of proceedings, B observes that an entry has been made in A's account book that some additional embezzlement has been taken place, which entry was not in the book, whose entry was not in the book at the commencement of his employment. Now, this being the fact observed by B in the course of his employment, showing that a fraud has been committed since the commencement of the proceedings, it is not protected from disclosure. As per section 127, the provision of section 126 applies to interpreters, clerks, servants, of barrister, attorney, pleaders, or vakils. Section 128, it speaks about privilege not waived by volunteering evidence. If the lawyer voluntarily appears before the court as a witness, he does not waive the privilege afforded under Section 126. But if the client questions the lawyer regarding the secret information or secret communication in the court, his consent is deemed to be given. Meaning, if the client questions the lawyer regarding the secret information in the court, it is usually presumed that the consent of the client has already been given and the lawyer can make disclosure of such communication before the court. Section 129, it speaks about confidential communication with legal advisor. The bar of Section 126 is partially lifted by Section 128. Here, this section applies where the client is being interrogated. Now, the client is being questioned before the court. He cannot be compelled to disclose any secret communication between his legal advisor and him unless he offers himself as a witness. Thus, from Section 129, it is clear that the privilege given under Section 126 is to protect the client and not the advocate. And in case a waiver has to be made, it has to be made by the client himself. And the advocate or the lawyer does not have any privilege to make waiver. And the client can make waiver merely by offering himself as a witness and when he discloses any information regarding such communication. Conclusion. The rule of privileged communication exists in the society because privacy and confidential relationship is valued. This is the main reason why these privileged communications are held inadmissible or not admissible as evidence in the court of law. So with this, we come to the end of our discussion on privileged communication. Thank you.